Welcome everyone to our Exploring with Fearless business session, which is going to be a two-part piece of content today. Today, I'm joined by Loretta Maxfield and Kirsty Stewart from Thorntons Law, where we'll be discussing intellectual property and data. Thanks for joining us today. Firstly, Loretta, can I invite you to explain to us a little bit who you are and what you do?
Yes, of course. So as James said, my name is Loretta Maxfield. I'm a partner at Thorntons Law Firm, which is a Scottish legal firm. I head up the data protection team in Thorntons, and we provide ad hoc data protection advice to lots of different sectors, including the creative industries. And we also deliver an outsourced data protection officer service, which is a key part to our service delivery as well.
Perfect. Thanks very much, Loretta. And Kirsty, the same to you. Can I can you explain a little bit about who you are and what you do as well, please?
Yes, of course. So I am a legal director at Thorntons Law as well, working with Loretta. I'm working mainly in our intellectual property team, specialising in all types of intellectual property, but particularly trademarks and branding is kind of my area of expertise. And also I do a lot of work with copyright as well in the kind of music industries in particular. I'm also dual qualified as a trademark attorney, so lots and lots of advice on trademark registrations and brand protection.
Perfect. Thank you very much, both. So previously mentioned that this will be a two-part session. So firstly, Retta, will we be able to discuss some data topics?
Yes, of course.
Okay. So firstly, what is data and how does this relate to the creative economies?
Well, data can be personal data when you're talking about data that might directly or indirectly identify or relate to a living being, or it could be non-personal data. So it could be data about users using your website. It could be data about your strategy, about your best customer fit. So it's not particularly directed at a particular individual, but it's very valuable data nonetheless.
And so what is meant by like sensitive data, for example?
So sensitive data is a term that was used under the old data protection regime, so pre-GDPR, General Data Protection Regulation, and it was used to signify that higher risk type of personal data. It's now called special category data, so it's a slightly different name, but essentially it still means that high risk data. So we're talking about data about individuals that concerns their health information, their sexual orientation, their political beliefs, whether they're part of a trade union, biometric data. So it's really their high risk information that we're talking about when people say sensitive data or special category data.
And what is meant by personal data? Because those are different but almost interchangeable things.
Yes, so personal data is the term used to cover off special category, that high risk data, but also the less risky personal data. So someone's name, their telephone, email address, maybe comments about that individual, perhaps how they're performing in their role as an employee. So all of it is personal data. That's like the global term for information that relates to someone either directly or indirectly. But the higher risk type of personal data has that separate name called special category data.
And you mentioned GDPR. Now, what is GDPR and who does that apply to?
So GDPR, which I'm sure most of your viewers will have heard of, it had an absolute massive marketing campaign when it came out. So it originates from Europe, and it's called the General Data Protection Regulation, and it was basically completely reformed data protection, and the effect it had on the UK was that it reformed the Data Protection Act 1998 that we had. Now we've left the EU, we now have our own version called the UK GDPR. It's very, very similar to the EU GDPR at the moment, in fact, almost identical, but that may well change in the future because the UK Department for Culture, Media and Sport are currently doing a consultation to consider how the UK can actually have its own regulatory regime for data protection, and we might see it coming away from the EU GDPR, but at the moment they're very, very similar. And it applies to all organisations in the UK that process personal data, either as a controller, so that's an organisation that decides what data to collect, what to use it for, how long they're going to keep it for, or as a data processor, and that's generally an organisation that processes data on behalf of the controller. So typically could be, for example, organisations that say provide cloud platform services that they're hosting the data, they are processing it, but they're not deciding what the controller does with it. So there's two different types of organisations involved, but they're both caught by the UK GDPR.
Thank you. And what are, if I have a business, or like I'm a small business or a sole trader, what are my obligations as a business with regard to data, and how does GDPR or UK GDPR affect that?
In terms of personal data, so
yes,
yeah. So the UK GDPR is just focusing on personal data, and I should also mention the UK's Data Protection Act 2018. So both pieces of legislation are very relevant to the processing of personal data. So it's quite a big question about what they need to do to comply, because the GDPR just has so much to it in terms of what you require, but generally what organisations should be doing is looking at their compliance levels at the moment, looking at the requirements of the UK GDPR and mapping themselves against those requirements, then identifying gaps in their compliance and putting together almost a plan. We would call it a privacy plan or a compliance plan, and working through that to meet their compliance obligations. But on a high level, what they want to be doing is making sure that they comply with the legal, the data protection principles, which are in Article 5 of the UK GDPR. And these essentially set out that you must have a lawful basis to process personal data. So it's really important that they consider, why are they processing this personal data? Is it necessary? Can they achieve the same end results without processing the personal data? They'd also want, so it's about having a lawful basis, making sure it's fair, that you're not going to prejudice people by processing their personal data or cause them harm, making sure they're very transparent with what they're doing. So making sure you've got the right privacy notices, you're telling people what you're going to do with their data, making sure people are aware of their rights in terms of if they want, for example, you to stop marketing to them, if they want you to erase their data, making sure people know. So really focusing on being fair and transparent with people, making sure that you use it for a clear purpose, and you don't keep it for any longer than what you need to. You've got appropriate organisational security measures around those data. If you are going to transfer it outside of the UK, make sure you consider, because that's quite a high risk thing to do. It happens all the time, but you need to be able to consider the protections that you put in place to make sure that transfer is lawful. And making sure as well a key thing, a key cornerstone of GDPR and good data protection compliance is accountability. And this is making sure that you can almost document and demonstrate your compliance with the data protection regime. So you'll be looking at things like making sure you've got all your privacy notices in place, making sure that you can document the organisational security measures you've taken, that you've considered the risks and you've put in place mitigation strategies to protect against those risks. Perfect,
thank you very much. So that's from a person point of view, someone's looking at your website, what is an individual's rights under GDPR? For example, there's something that we hear about consent within that. Can you expand on that a little bit for our audience?
So consent is a legal basis for processing, essentially, in the context of data protection. So if you may obtain someone's consent to process their data, consent is not always the best option in actual fact. I would recommend you look to see if there's any other options first, because the key thing with consent is it's quite a high threshold under GDPR. It has to be very clear. Individuals have to demonstrate a positive indication of consent. So implied consent is a big no-no under GDPR. You've got to make it easy for people to withdraw their consent. So if you're going to rely on the consent, you have to be aware that people can withdraw that at some point and then you need to stop. So consent is quite a high threshold. So I would always recommend that you look to see if there's another lawful basis that's more appropriate. But if not, sometimes there's not. If not, make sure that you're very clear, the consent is granular and you're not bundling in consent for a few different activities. People should be able to pick and choose what they're consenting to, and making sure that you've got a documented record of their consent, and making sure that if someone withdraws their consent, that you act upon that very quickly.
Perfect. Oh, sorry.
I was just going to say, you know, in terms of the actual rights that they've got under data protection legislation, it's really important for organisations that are processing personal data, you know, your viewers, that they're aware of what rights people have, and that they make sure people are aware of how to exercise those rights. So you're talking about the right to get access to the data you hold about people. So you have to have the back-end processes in place to make sure that if someone asks you for a copy of their data, you know how to do that, and you know that you must respond within a month, subject to certain exemptions. And there's also other rights as well that they need to be aware of. So, for example, the right of erasure. Individuals can ask for their data to be erased. Individuals can ask for inaccurate data to be rectified or to be transferred to another party. So there's various different data subject rights that individuals have. Perfect.
If I am running my own business or I'm acting as a sole trader, is there anywhere that I can go for advice with regard to GDPR and best practice?
Yeah, the Information Commissioner's Office website is actually a really good resource. It's ico.gov.uk. That's got a wealth of information about data protection, marketing, lots and lots of guidance notes. They've also got a helpline as well, and they've actually got a dedicated area for the SME sector, which is quite useful. And the government website, the UK government website is also quite useful for information, for example, about data ethics.
Perfect. Yeah, because one thing we're going to check is that more businesses are looking for models to rely on customer data to create revenue or target key demographics more effectively. Are there any moral considerations that arise from this as from a business practice in regards to using people's data?
Yeah, I mean, ethics is very, very important. Almost the cornerstone or the spirit of GDPR is to respect and uphold an individual's right to their information, and not for their personal data to be treated fairly and them not being prejudiced by, for example, big corporate bodies trying to build a business on the back of people's data. So the legislation is very much drafted, in my opinion, in favour of the individual citizen. So ethics is a huge part, and it very much aligns with the spirit of data protection legislation. And so the key things that, particularly if you're working in the public sector or in the research fields, but the key things you would want to think about is, again, going back to transparency. Be really open and transparent with people about what you're going to do with the data. Make sure your privacy notices are not full of legal jargon. Make sure they're concise and to the point, and in a language that people will understand. Make sure your use is fair. Think about what impact is this going to have on individuals. Is it going to be unfair? Is it going to feel harassing to them? I mean, sending someone 3 marketing texts a day is just going to be annoying, and that's going to be something that you probably will come to the attention of the ICO at some point, and perhaps get into trouble over. So think about, is it fair what I'm doing? Am I causing them any harm? And again, coming back to that accountability, make sure that you can demonstrate that you have considered the risks. Do a data protection impact assessment if it's going to be something that's going to cause a risk or likely to cause a risk. and make sure that you can demonstrate you've considered all of the issues and put in place mitigation procedures.
So you mentioned there about data protection impact assessments. What is that? And also, do I need to have a data protection officer as part of GDPR?
So a data protection impact assessment is essentially a documented assessment about a process or a procedure or a new project that you might be doing. And it's essentially to tease out the issues to see if there's any risks to the individuals, for example, that might arise as a result of this project. And it's meant to be a risk management process. And then at the end of it, you would then set about your risk mitigation strategies. You would assign responsibility for addressing these to people within the organisation, and your DPO or someone in the organisation who's responsible for data protection compliance is meant to revisit the DPIA regularly to make sure that action points have been addressed. If it's something that cannot be addressed, the risk cannot be mitigated, but you still want to go ahead, you should really go to the ICO to have a consultation on this. And if it's something that is just quite high risk and the ICO are not happy for you to proceed, then you should not proceed. So a DPIA is really a risk mitigation strategy. And again, it comes back to this accountability, which is just the cornerstone of GDPR, about being able to demonstrate that you have considered the rights of individuals in your processes. To DPOs and whether you need a DPO for your organisation. Organisations that require by law a DPO are public authorities, organisations that are regularly and systemically supervising, monitoring individuals, or individuals that process high volumes of special categories of data such as health or criminal data. So these are the organisations that must have a DPO, but many organisations voluntarily choose to appoint a DPO because the risks with non-compliance with GDPR are so significant that they feel it's of huge benefit to have someone with that expertise surrounding data protection, even if they're not legally required.
Okay. And are there sort of any fines and penalties under GDPR? What are they?
Yeah, GDPR has quite significant fines. So it's a two-tier fine system. The first tier is 2% of global turnover, or £7.5 million, the greater of. And then the second tier, which is reserved for the more severe breaches, is the higher of 4% of global turnover, or £17.5 million. So they're quite significant fines for any size of organisation, really. So it is quite a serious issue.
Very important topic. That's been great. Thank you very much, Loretta. That's been very, very insightful.
That's okay, thank you.
And for part two, we're going to be taking an overview of intellectual property. Kirsty, thank you for joining us today. So to kick off, what is meant by IP and how does this relate to the creative economies?
Yeah, so IP stands for intellectual property, and it covers a wide range of rights. So it includes copyright, trademarks, rights and designs, patents, database rights, and potentially also trade secrets as well. So copyright, for example, protects the expression of an idea. So it covers things like literary works, books, dramatic works, musical works, artistic works. It also covers things like software. So for example, it would include books, plays, computer games, paintings, films, all of those would be covered by copyright. Patents protect inventions which have an industrial application. So that's things like computers, light bulbs, mouse traps, different pharmaceutical products, that sort of thing. Anything which is kind of an invention of a product or a process. Trademarks, they're there to protect brands mainly. So it's things like words, slogans, any distinctive shapes of products. Even things like sounds and colours can potentially be protected by trademarks. Things like the kind of Tiffany jewellery box colours, Milka chocolate bar, the kind of colour of that wrapper. Those are only in quite extreme circumstances, but they are the kinds of things that can be protected by a trademark. We've also got design rights, which protect the shape or the appearance of a product rather than the functionality, which would be a patent. So designs are more about the appearance and the shape of something. So that's the main types of IP.
Perfect, thank you. And what rights does a creator have?
So that varies slightly depending on the type of IP. So if we're talking about copyright, then that tends to be the right to, well, you have the right to then use that work for whatever purpose you want, but you also have the right to prevent other people from making copies of that work, kind of making it available to the public, so presenting it publicly, that sort of thing, adapting the work. All of those things are things that you would be able to prevent as a copyright owner. For trademarks, you are essentially preventing someone else from using a similar or identical trademark or brand for similar or identical products or services. So it's giving you rights in a particular area for that particular brand and helping to protect your brand and make sure that it's, you know, that the kind of goodwill that you've built up and the recognition in that brand is protected and can't be copied or taken advantage of by someone else. So that's probably the main thing. For design rights. It's similar. It's protection against someone copying your design or producing something which is substantially similar and which might confuse consumers. You know, something which creates the same overall impression as between the designs. So that's your kind of high level rights as an IP owner.
And if I have a business or I'm a sole trader, this may seem like a very straightforward question, but why is IP and IP considerations important?
So in the creative industries in particular, IP is really important and tends to be a kind of core asset of what a lot of these businesses do. So obviously, if you're a musician, then your music's your key asset. If you're a writer, what you produce is so important to the business. If you're a kind of line of products, then the brand name and look and feel of those products is absolutely core. So especially in the creative industries, I think it's really important to think about what types of IP do I have here and why should I protect those? So yeah, I think for any business in the creative industries, there's likely to be some IP there that's going to be quite important. So it's thinking about, is there anything I actively need to do to protect that, or is it an automatic right which exists?
And when is, if it is something that needs to be protected, when is the best time to look at protecting that IP?
So normally we would say the best time to protect it is as soon as possible. So if you're talking about a brand or a product name or that sort of thing, if you're going to launch that on the market, then you really want to have trademark protection in place for that right from the outset, or at least understand what rights you have in that brand, so that when you go to launch the product, you know that for one thing, you won't come up against anybody else who has already done something similar, who's going to say, hang on a minute, you can't do this. Or on the other side of the coin, you launch the product and then everybody thinks, what a great idea, I'll jump on the bandwagon. So it's important to have protection in place as soon as possible.
Perfect, thank you. And if you're working with third-party providers, are there any key IP considerations that you should look out for?
Yeah, so I suppose the starting point is that UK IP or copyright law says that the owner of IP or the owner of copyright in particular will be the creator of that copyright work. So if you're working with a consultant, a website developer, any third party who's working on your projects, the default position will be that anything that they create is owned by them unless you have an agreement in place to the contrary. So it's really important when you're working with any third parties to think, do we have terms and conditions in place with them? And what do those terms say? Do I own what's going to be created by them, or do I at least have the rights that I'm going to need to be able to use that going forwards? The only exception to that rule is that if you're an employee of a company, then anything that you produce will generally be owned by that company rather than you as an individual. But generally speaking, if you're hiring an external consultant or working with someone external to your company, then they will own what is created. So it's really important to think about what they're creating and how you're going to want to use that going forwards to make sure you've got the right terms and conditions in place and the correct rights for taking that forward.
Perfect, thank you. And on the subject of copyrights, how do I register a copyright, and is there a fee?
So in the UK, copyright is an unregistered right. So there are no requirements to register it. It exists automatically as soon as you put pen to paper, if you like. So as soon as you have written down your ideas for a book or a poem or painted a picture, recorded it in some way, that copyright exists automatically. That's not the same in all countries. So the US, for example, there is a register of copyright, but in the UK, that right is automatic. So there's nothing that you need to do to register copyright in the UK. But having said that, you can draw people's attention to the fact that you are the copyright owner by marking your work with the little copyright C symbol, which you've probably seen on a lot of things. And it's usually then also marked with the name of the person who created it and the year in which it was created, just to kind of assert your rights and make it clear that this belongs to someone and shouldn't be copied. But there's no actual need to register the work.
And how long does a copyright last, and is that different in different territories?
Yeah, so in the UK, copyright generally speaking will last for 70 years from the date of death of the author or the creator. So it's a pretty long lasting right. I suppose that there are differences from jurisdiction to jurisdiction. So when you're looking at using, for example, a very old text of a book or something, it may well be out of copyright in the UK, but certain versions of it or certain publications of it may not be out of copyright in other territories if they have different rules about how long that lasts. So it's always worth thinking about which version of this do I want to use, when was it published and where, when you're trying to work out what rights you might have, because it might not be the same in every country.
Perfect. And just for reiteration as well, what point in the creative process does copyright occur?
Yeah, so again, it's as soon as you put pen to paper, as soon as you create something. So it depends on the type of work. If it's, a computer game, then it's the point at which the software code behind that work is created. If it's music, it's the time that the kind of musical score and the lyrics are written down. So that's when it comes into force, as soon as it's created.
So what are a copyright owner's rights with regard to their copyright, and what could be seen as an infringement of it? So
I touched on briefly the rights that you might have. So it's the right to prevent someone else from copying your work or a substantial part of your work, making adaptations of that work, kind of selling copies of it to other people, presenting it publicly on the internet, or presenting a version of the play that you've written or something like that. And also you have various rights as a copyright owner as well to always be acknowledged as the author of that work, and also to object to any kind of derogatory treatment of your copyright works. Now, there are a few exceptions where you are permitted to use a copyright work. So that tends to be known under the kind of banner of fair dealing, which basically means what might be considered to be fair use of a copyright work. So, for example, if you are writing a book and you want to refer to other books or other essays or copyright works within that, if you are only using a small quote from that work and you're acknowledging where it came from, that might be considered to be fair use. You're not using the whole thing. You're not just wholesale repeating what's already come before. You're using it to enhance a new copyright work as a reference, I suppose. So anything which would be considered kind of criticism or review of a previous work, as long as you're not using excessive parts of that work, that might be considered to be okay. But generally speaking, copying of copyright works is not permitted.
Thank you. And what happens if my say IP is infringed, but that happens overseas? What happens then when the different frameworks collide, so to speak?
Yeah, so I suppose, again, it depends very much on what type of IP has been infringed. If we're talking about a trademark, then trademarks are very much territory specific. So you would apply for a UK trademark, an EU trademark, a US trademark, etc., depending on where your activities are. So if you have a UK trademark and someone sets up doing something very similar in the United States, for example, there might actually be very little that you can do about that unless you're already trading in the United States. Or the other example would be if the other company is set up in the US but operating via a website which offers products or services to customers worldwide. So even though they're based in the US, they might be, you know, dispatching products to the UK or offering services to customers in the UK. That might be sufficient to rely on your UK rights. And if it's copyright, it is slightly more complicated because you have to work out which regime applies. If it's your copyright work and you're based in the UK, then it's likely that it will be the UK copyright laws which will apply. But even so, when you're dealing with infringements overseas, there are added complications in terms of it's usually more costly to deal with something overseas. And also, even if you're able to, for example, have a court judgment here which says, yes, they're infringing your IP, there are slight difficulties in how might you enforce that in the other country, depending on where it is and how kind of developed their IP system might be there. So it is slightly more difficult when you've got an overseas element.
Thank you. I mean, and you said previously there that, you know, things can be costly. I think the whole IP subject can be quite costly as well. Are there things to consider and balance for small business when making a decision to protect or to not protect?
Yes, I think you need to look at, as I say, the IP that your business has and what its plans are for the kind of short to medium term future, and work out, you know, what is it that I'm trying to protect here? What are the assets that are going to be important to me going forward? If it's copyright, you know, there's nothing that you really need to do. It's there already, but you do need to watch out for someone copying that and to take action if it's appropriate to do so before that gets out of hand. If it's things like trademarks or designs, you do have some automatic unregistered rights in both of those. So if you've, for example, been trading under a certain name for a few years, then you will have automatically built up goodwill and reputation in that name, which you could rely upon to try to stop a third party doing something similar. But at the same time, if you have a registered trademark, that process tends to be a lot easier because you are simply pointing at your trademark registration certificate and saying, these are the rights that I have. If you have unregistered rights, you have to show you've built up goodwill, there's a reputation there, there's been some sort of misrepresentation or action taken that would cause you damage, and that you've either suffered damage or you're very likely to suffer damage. So there's a lot more hoops to jump through if you don't have protection. So it is a bit of a balancing act. What do I need to protect? And, you know, the temptation might be to try and protect absolutely everything, but you will then see yourself racking up quite extensive costs. So it's quite important, I think, to get a balance. What are the key assets? What's going to be our main products? What's going to be our main asset that we want to protect here? And start off with that. And then as your business grows and develops, you can expand that protection at the same time.
Perfect, thank you. And at what point would I need to engage a lawyer in managing my IP?
So again, it depends on the extent to which IP is relevant to your business. So most businesses will have some sort of IP, so a product name or, you know, a website domain and website content which is relevant to their business. But there are a lot of businesses for which IP is not core, it's kind of incidental. Whereas in the creative industries, as I say, it does tend to be more of a core consideration. So if you've only got kind of one or two copyright works, you might feel that there's not too much that you really need to do there. But if you're then, you know, entering into licensing deals with third parties for those works, you might want to have a lawyer look at the contracts for those. And again, if you've got lots and lots of copyright works, lots of designs, lots of product ranges, a logo or a business name which is going to be really core to you in terms of a brand, then you really want to make sure that those are properly protected, and that's when we would always advise you speak to a lawyer to get some expert advice on that.
Perfect. Thank you very much. And is there anywhere that provides, obviously we mentioned that there's lawyers as well, but is there anywhere there is advice on the subject as a whole also?
Yeah, so similarly to what Loretta was saying, there is an intellectual property office website which has a lot of information on it. The website address is ipo.gov.uk, and that's got information on all the different types of copyright and how you might protect those in the UK, and also it has some information on protection overseas as well. And it just gives you some general information on how those types of IP come to exist, how long the protection lasts, and how you might go about registering them if that's appropriate to do so. So that's probably your main starting point. And as I say, if it's something more complicated or you have a lot of IP, then we'd suggest that you speak to a lawyer. And we do quite a lot of work in the creative industries, and what we tend to do is have a kind of short, no cost consultation just to get a little bit more information about the business and give you a little bit of reassurance on what you might need to do. And then we can also give a quote, obviously, for any work that might need to be undertaken going forward. So yeah, it's a balance between kind of information that's publicly available, but then also recognizing when you might need some more in-depth help with the IP.
Perfect. Thank you very much, Kirsty. Well, that brings us to the end of today's very useful session. A lot of valuable insight and information regarding two very important subject matters. I'd like to thank you, Loretta, and you, Kirsty, from Thorntons Law today for joining us, and also to all of our viewers at home watching. Please don't forget to follow us on Facebook, Twitter, and LinkedIn, and please make sure to check out our website on www.expertnorth.co.uk for future content and creative economy support. All of the links from today's sessions, including links to Thorntons Law, will be added to today's content session also. Thank you very much. Thanks for joining us.